Hi, Reverend Tony Suarez here with you to discuss the chapters and some of the concepts and principles of my book on religious freedom. We call it What's the Law Got to Do with It? Understanding Religious Freedom Law. And in my position as a minister and a law professor, I thought that I could have some illustration, some help to help people try to understand what's going on in our courts, because they really don't understand why the courts rule one way or another, and it's confusion, and when there's confusion, people lose faith in the government, and that's what we don't want. We want people to believe in their government so that we can have some peace. Now, one of the courts, when they make decisions on cases, have tests and different ways to try to balance it. If you've seen the previous chapters, you know that the courts have to go through a balancing between individual rights, group rights, whether or not you have the right to religious freedom or religious establishment, other different kinds of rights that we discussed, right to privacy, etc. But the courts have to look at this and try to balance. And so there are different tests they use. One's called a rational basis test. Does the court use a rational basis? Does the state have a rational basis for which to make the discrimination? And the reason I use the word discrimination is because every law causes someone to lose something and someone to gain something. Right? There's always a winner or loser, which is why we have lawsuits. In the lawsuits, we have someone who's getting hurt and someone who's getting a favor, and they end up in a lawsuit, and then the court has to determine whether the law that is being used is constitutional. And what that means is, does it fit within the framework of the rights given to the government? Does the Constitution, which is the document that governs our form of government and democracy, did the government who's made this law, whether it's the federal government or state government, do they have the right to make such a law? And thus, they have to come up with some sort of tests and some sort of guideposts, so both lower courts and the legislatures who are passing these laws have a guidepost as to what probably will pass muster and may not pass muster. One is a rational basis test. The government, the legislature passes a law. Do they have a rational basis to make this law? The other test is called the strict scrutiny test. And that test is a higher burden test. And that test says when the court of its legislature in the law imposes a severe burden about an established right, like a right to privacy or right to religious speech or religion, right to speech, right to bear arms. If the legislature is imposed a restriction on a fundamental right, then we have to look at that law differently, not merely with a rational basis, but by a test that we call the strict scrutiny test, saying, is the law narrow enough to make sure that it's only covering a small number of incident cases? Does the state have a compelling interest? It has to be a really compelling interest for the state to get into and to restricting those rights is narrowly drawn in order to get to that right. And so we're going to be looking at that test to determine whether or not the government has the right to make that restriction. So let me just read it to you as I got it in my notes. Does the state have an overriding and compelling interest in the activity it is trying to regulate? And B, is the government restriction narrowly drawn or so tailored to minimize its effect? If it is too broad and that it infringes on the rights of the citizens, then the alternative, and if an alternative is available, then the law must be struck down as being unconstitutional. Now, that's a two-pronged test, right? And the courts have to go and do an analysis, look at the facts, look at the law that's being applied to determine whether or not there's a compelling state. So I go, in order to highlight this, I go to different kinds of tests. For example, the case of Mr. Seeger, who's in a theology group, and he said he believes in the cosmos represents the feline nature of animals on Earth. Right? This has a higher consciousness. This is his beliefs. He tried to get a exemption, military exemption from the army, so he would not be determined to be draftable. The court then had to go into determination of, is this a religion? What kind of faith is this? And the court has to go to an analysis of whether or not it was appropriate for the government to say, no, we're not respecting your faith, whatever that is, you call it, and you're going to have to get drafted. So the test is not rational basis. The court determined we have to look at this with a strict scrutiny to determine whether or not that religion was in fact sufficient to qualify. And that is, you can imagine how difficult that would be for the court to determine what is a religion, how strict do religions have to be. What kind of religion? Any kind of religion? What is religion? It has to be defined. Another interesting case is a case it comes out of Florida, where sacrifice of animals. There are religions, and in particular one in Santeria, where the sacrifice of animals is part of their religion that came from Africa, and that was part of what they do. But however, the people of Hialeah who found out that it was doing these sacrifices were offended by what they called the torture of the animals, and they passed laws to prohibit the torture, sacrifice of animals. That case goes up to the Supreme Court to determine whether or not the sacrifice of the animals is in fact a religious practice, and whether or not the people of Hialeah, as a government, have the right to restrict the rights of those people to sacrifice animals, and can they do it? Another interesting question is whether or not there was the case he came out again out of Florida of a young lady who wanted to not uncover her face. In her faith of Islam, she had to cover her face, and she did not want to give a picture for her driver's license. The question had to come up: is this her individual right, her right to her religious beliefs, and the government's right to have identification, a driver's license, full face for the police? Those two clash. And now, are we prohibiting her in the First Amendment by this law that requires full facial exposure? Are we prohibiting her under the First Amendment from practicing her faith? In that particular case, the court had to go into litigation to determine what is the practice of Islam. Is that an acceptable practice? Is it an acceptable practice from which she has a right to impose? That case is complicated, but it's all explained inside this particular chapter. You will find compelling people who want to smoke peyote, sort of form of marijuana. That's as a religious practice. Others that grow beards as religious practice are inside the jails. And the jail says you must cut your beard. But how can I cut my beard? It's part of my religious practice. Those questions are clash. We go into quite a bit of detail in the book, trying to explain the tests that the courts will use to determine when someone's right to religious belief overcomes the state's interest in whatever that may be, but be it security or whatever the state is trying to establish with their law. When it clashes, what test we use, we're going to use strict scrutiny, and what factors are going to be used in order to make that test. Again, we teach whole law school classes on this topic, but I'm hoping by you reading through this chapter, you will have gained some insight. Thanks.